All right, everyone, it's 2:00. Let's begin. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I am Judge Melanie Williams, and today is June the 15th of 2023. All defendants, let me make sure it's courtroom 2. Courtroom 2 is on the screen. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney at this proceeding. All participants, this particular proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this particular proceeding. Those who receive a surety bond today will be reset. Ms. Bridgewater, what is my reset date?
It's June the 29th.
All right, thank you. Those who receive a surety or cash bond today will be reset to the June the 29th calendar. Those who receive a signature bond, whether through pretrial or the jail, will be reset further notice. All right, who do we have first at the jail? And wait, before we begin, have all attorneys had the opportunity to interview their clients, and are there any other announcements?
Yes,
Hearing, yeah, all right, thank you. Hearing none, let's begin. All right, who do I have at courtroom 2?
Position 6 and 7, Mr. Cole.
All right, good afternoon. All right, Mr. Cofield, you have 2 cases. Your cases are 23 CR 003809A. In that case, you're charged with simple battery with the offense date of August 23rd. In your second case, 23 CR 003810A, you're charged with battery, family violence, and criminal trespass with the offense date of April the 14th. Do you understand your rights?
Yeah, I understand all right.
You do understand your rights?
Yes.
Okay, thank you. Mr. Howard, can I have his history, please?
Fifth arrest, 2021 battery DV. It's 21 CR 005610A as an apple. 2015 misdemeanor possession of marijuana. 2014 theft by receiving, auto, and obstruction.
Okay, thank you. Ms. Falk, is this your case?
This is
No,
actually
Your
my
Honor,
case,
it's
Judge.
Mr. Jordan Robinson's with the third, has under the Third Year Practice Act.
All right, Mr. Robinson, please proceed with a brief summation of the state's facts and position, as well as the recommendation for the bond for both cases, please.
Yes, ma'am. So as far as the simple battery violence case, that's a 23 CR 003809A. Officer arrived today. Oh, sorry. The incident happened at 2423 Martin Luther King Jr. Drive, Southwest Atlanta. Officer arrived to the incident location for a dispute call. The victim, Mrs. Lauren Quay, stated that a dispute happened between her and her living boyfriend, Cofield, and stated that the incident happened as a result of her asking the defendant to take the child to daycare, where he got upset, causing a verbal dispute. Mrs. Quay then stated that the victim had pushed her. The defendant had pushed her, and they began fighting in the living room, during the course of which her hair was pulled. She called her father, and her father called 911. As far as risk of reoffending, he's been arrested for battery, family violence in 2021. Already had a $5,000 signature bond from the 2021 case. No further contact was the condition. He violated it. Bond was set by Judge Murrow the bond was set by Judge Murrow on the 19th of October, 2021. The victim and the defendant are no longer in a relationship. They don't live together anymore. They do share a child, however. The victim confirmed the events and the warrants. The defendant does have the previous case from October 18th, 2021. That's the case number was 21CR005610A. And the defendant was ordered to have no further contact and stay away from the residence. The victim stated that there was some contact with the defendant since the April 14th incident, but hasn't been any violence since. And for all that, Your Honor, we're asking for a $2,000 cash bond, stay away from 2324 MLK Drive, and no further contact with the victim, Your Honor, and no alcohol, drugs, and weapons.
And the victim's last name again, I got Lauren. What was the last name?
On the report, it said Quay. It was. I can pull it up. Hold on, please.
Can you just spell it? And is she the alleged victim for both positions?
Yes, ma'am. Yes, ma'am.
Okay.
That is Quaye.
Okay. Is Ms. Quay present on this Zoom conference? Okay. Before we go to the defense, very quickly, Mr. Robinson, you said you're requesting a $2,000 cash bond. Is that for position 6 and 7? Or was that just for position 6? What was your request for position 7?
Position 7. So for position 7, is that case 38108?
Okay, on the calendar, yes, it ends in 3810A. Yes.
Okay, is it okay if I state the additional facts for those two charges?
Yes, I like it.
Okay.
Yes, go ahead. I'd like to do all of that at once, please. Thank you.
Thank you very much. Same location. Officer dispute between the victim and the defendant. Mrs. Quay states that this time the altercation was because the defendant was upset that she was planning a birthday party with a friend. So the defendant starts getting loud. She goes to the the bathroom to go wash her son. When she's there, he takes the key. He tries to take her keys where she tries to retrieve it, and then they begin fighting. He begins pulling her hair, and it results in her getting scratches on her body, which was documented by body camera. The defendant he proceeds to use a wooden 2x4 to damage the television of the victim, and he kicks in 2 holes in the living room wall. And he had a $5,000 signature bond from the 2021 case. No further contact was the condition. He violated it. Bond was set by Judge Murrow on 19th of October 2021. And for this case, Your Honor, we're asking for a $3,000 cash bond, $1,000 on. Sorry, hold on. Yeah, a $3,000 cash bond, and to stay away from 2324 MLK Drive, and no further contact with Ms. Lauren Quay, and no alcohol, drugs, and weapons.
Okay, thank you. All right, Ms. Wills, is this your case?
It is, Your Honor.
All right, and at the jail, can we please go to the position after this one belonging to Attorney Butterfield, please? Thank you. All right, Ms. Wills, please proceed.
Thank you. My client is 30 years old. He is a Georgia native. He is employed by Fox Brothers Barbecue as a line cook, and he's been employed there for 1 year and 5 months. He will not qualify to receive our services. He does have a high school diploma, and states that he works 6 days per week and was unaware that he had warrants out for his arrest. He does have 2 children, one of which he shares with Ms. Quay. My client does deny the allegations and states that Ms. Quay wants to continue their romantic relationship. However, he is not interested in being with her, and she has taken out these warrants as a form of revenge against him. He does not want to have any further contact with her. The alleged injuries are hair pulling and scratches. I would ask that Your Honor either give a signature bond or the lowest bond possible, that it not be a cash bond, as my client will not be able to afford that. Also, that 2021 case, and speaking with my client, I believe he has served his probation. That's been concluded. So I know that was mentioned several times.
All right, thank you. At this time, as it pertains to position 6 ending in 3809A, defendant will receive a $2,000 surety bond. He is to stay away from the location on MLK Junior Drive, have no contact with the victim, and have no alcohol, drugs, or weapons. As it pertains to the position 7, the case ending in 3810A, defendant will receive a $3,000 surety bond, broken down $2,000 for count 1, $1,000 count 2 for the trespass. Same conditions, no contact with Ms. Quay, stay away from that location, and have no alcohol, drugs, or weapons. Is there anything further from the state of the defense?
Nothing further from the defense. Mr. Cofield, please, you have the right to remain silent, and I do not advise that you say anything at this juncture. You will be able to fight these charges at a later date. You received a surety bond, not a cash bond.
Number 6 was 2,000 or 1,000?
2. All right. Mr. Butterfield, good afternoon. Who is your client?
Good afternoon, Your Honor. I'm here on behalf of Mr. Elijah Whittingham, Your Honor.
Okay, let's see. Are we able to take that position?
Yes, Judge, that's fine.
Thank you.
That is position number,
15.
okay. Thank you.
All right, Mr. Whittingham, your case is 23 CR 003811B. You're charged with obstruction with the offense date of June the 14th. Do you understand your rights?
Yes.
All right, Ms. Howard, can I have the history, please?
Second arrest, 2018 marijuana possession.
Okay. Thank you. And is this your case, Ms. Falk?
Yes, it is, Your Honor.
Okay,
So
please
this,
proceed.
yes, Your Honor. So this happened June 14th, 2023 at 3475 Jonesboro Road Southeast. Officers had pulled over the defendant's brother, Chaz Whittingham. And while speaking with him, they smelled the odor of marijuana coming from the vehicle, saw an extinguished blunt in the center console. At that time, the defendant then approached the traffic stop, began to inquire for the reason for the stop. The officers asked him to keep his distance. The defendant did not, unfortunately, take their advice and continued to argue with the officers, refused to step away, and continued to come closer to the officers while they were trying to search the vehicle. So at that point, they placed him under arrest, and he did resist arrest when they placed him under arrest. Just as a side note, they did find a number of drugs inside the car, including marijuana, psilocybin mushrooms, and what looks like MDMA inside the vehicle. So Mr. Chaz Whittingham was charged with those charges. We are agreeable to a $2,000 signature bond through pretrial services, no alcohol, drugs, or weapons. And that is all of the conditions that we will ask for at this time, given Mr. Whittingham's history. That's all for the state.
I'm just curious as to whether blunt is the actual technical term. I'm guessing it is. All right.
That is the terminology they use, Your Honor.
I mean, I've heard that and familiar with that term. I just didn't know if that's what we officially call that. All right, Mr. Butterfield, and based on information in your client's history, I'm inclined to give him signature bond and send it through the jail at this time with those conditions. Do you have any objection?
We don't have any objections, Judge. He is 23 years old, high school graduate, and this happened at his family's shop. They have an auto body shop, and apparently when his brother was stopped right at the shop, he came out and inquired. I will be speaking with Mr. Whittingham. I know the family very well, Your Honor, and I don't expect he's going to have any problem with being on bond, and I look forward to working with the state to get this matter resolved.
Wonderful. All right. At this time, defendant will receive a $2,000 SOB through the jail. He is to have absolutely no alcohol, drugs, or weapons as a condition, and he will be reset further notice. All right. Best of luck to you, Mr. Whittingfield. That's the end of your, Mr. Whittingham. And Mr. Butterfield, does that conclude your business before the court today?
That does conclude my business. May I be excused, Your Honor?
You may. Take care. Have a great afternoon.
Thank you, Your Honor. Have a great day.
All right. Who do we have
Oh,
next?
Judge, I do have one other question. I was going to do an entry under the 23 CR 003811B number. Would I send that to the badge request, or where would I send it to so I can appear on the calendar?
I believe you have to actually file it in Odyssey.
Okay.
Falk, are you familiar? Are you aware?
I would recommend that he do the e-file just so that he can receive a discovery on that case or if he needs court notification.
Well, thank you kindly. Y'all have a great day.
All right. Take care.
Position 1, 3 South, Bailey.
All right. Good afternoon. And has he earned his right?
No, ma'am.
Okay, that's quite unfortunate. All right. Good afternoon, Mr. Bailey. Your case is 23 CR 00380 In this case, you're charged with criminal trespass with the offense date of June the 14th. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney. I apologize, Miss Bailey. You also have a right to an attorney. This proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch this. Do you understand your rights and how I'm conducting this hearing today?
Yes.
Thank you. Mr. Howard, can I have the history, please?
11 total. Last was 2022. Damage to property. 2017 FTA NOD. 2017 trespass NOLO and an 08 shoplifting conviction.
Okay. You said 08 shoplifting?
Correct.
All right, perfect. Thank you. Ms. Falk?
Yes, Your Honor. Defendant was banned from Lenox Mall a month ago for sleeping there and harassing patrons, and appeared back at that location, was inside the Apple store at one point at 3393 Peachtree Road, Lenox Mall. Because of the prior stay away order, she was arrested. The state's recommendation is a $2,500 signature bond through pretrial services. Stay away from Lenox Mall, no alcohol, drugs, or weapons.
Okay.
No
Ms.
objection.
Wills, any objection? Okay.
No, Your Honor, and I've already spoken with Ms. Bailey about not returning back, and we have no objection to that as well. And I also sent an email to our social worker to assist her with housing.
Thank
All
you,
right.
Penny Wills. That's the only other thing I was about to ask for.
All right. So Ms. Bailey, you understand that we are going to grant you a signature bond today, but you absolutely cannot go back to that Lenox Mall location, all right? Defendant will receive a $2,500 signature bond through the jail. She is required to stay away from the incident location, have no alcohol, drugs, or weapons. And I'm going to ask that we just write BHET on the order as well. All right, best of luck to you. Take care. Have a good day. What do we have next?
Judge, I have a quick announcement for Mr. Contrell Levante Broughton. He was an add-on. Just wanted to know who's going to be interviewing him.
I'm sorry, I was unaware of an add-on.
Yeah, I ain't got no history for them either.
What is the name
Wasn't
again?
aware.
I didn't receive an add-on calendar either.
Okay.
Is this perhaps someone who should be on the felony calendar by any chance? Does anyone know? What was the name?
Contrell Levante Broughton.
What's the booking number?
Booking number is 230-9406.
He has a simple battery that they didn't handle a felony today.
They didn't handle it in felony because it's supposed to be in misdemeanor, or they just forgot?
They just forgot to handle it in misdemeanor. They forgot to put them on the calendar.
Then it wouldn't have a CR number then. I don't think we can do it.
It
I
doesn't.
spoke to Michael Jordan. I spoke to Michael Jordan. He's seen it. He said he's gonna send it to the solicitor. So we're just waiting to hear back. But it's a simple battery that's on his booking screen.
Yeah, I see it.
You see it, right? Thank you.
I'm unclear what needs to happen here.
I don't know, but
I guess-
I don't know.
Your
I'll be
Honor,
right back.
I will look into it. Can we just address other cases?
Yeah, I agree. Yeah, we definitely can do that.
I will be in the background trying to figure it out while we're going over the other
Can
case.
we take a case that's not assigned to Deputy Falk, and while she has a moment to look at that, who's sitting here before me?
This is going to be position 3, Burks.
Okay. All right, Mr. Burks, your case is 23 CR 003799F. In this case, you're charged with fleeing and attempting to elude, failure to obey control devices, and having, I believe, 2 dark window tint with the offense date of May the 23rd. Do you understand your rights?
Yes, Your Honor.
Okay, Mr. Howard, can I please have that history?
16 total. Got an open CP case, 21 CP 196. 830, fleeing an officer, reckless driving, obstruction, suspended license. 2019 probation. 2019 possession of a firearm by convicted felon, possession of a firearm during the commission, possession of a controlled substance. 2017 carrying concealed weapon, and 2015 possession of a firearm by a convicted felon and during the commission of conviction.
Okay, I think that's sufficient if you weren't already done. Is this Ms. Falk's position?
Yes, Your Honor, it is, but I'm actually doing two things. I'm looking at the.
Okay, you're good at multitasking. All right.
All
So
right.
please proceed.
So this happened May 23rd, 2023 at 3:20 p.m. Officers were observing the defendant driving in the area of Ralph David Abernathy and McDaniel Street. They saw that his front windshield was tinted, his side windows and rear windshield were so dark they couldn't see inside the vehicle. They went to make a stop and observed the defendant turning on red from McDaniel Street to Ralph David Abernathy on a no turn on red. They initiated a traffic stop. The defendant gave them a paper copy of his driver's license and asked for no citation because he had a CDL. But the officers could smell odor of marijuana coming inside the vehicle, asked the defendant about it. He was also breathing very heavy. So at that point, they asked him to step out of the car. He refused, put up his windows and sped away from the scene. And that was back in, as I said, May 2023, and they picked him up on a number of charges recently. He has that open 21 CP 1968-30 case for fleeing and eluding, suspended license and reckless driving, as well as obstruction of an officer. He was given UJR level 1 on that case in January 2021, and we're back again with very similar facts. He also had a possession of drugs and possession of a firearm in 2015 he received first offender for, and drug charges in 2020 that he received pretrial on. We are asking for a $5,000 surety bond, $4,000 for the fleeing and eluding, $500 for each remaining charge. No alcohol, drugs, or weapons, no driving without a valid license. Our concern is this is the second time he has fled from police. We do have some serious concerns about the risk of reoffense as well as the safety to others if he continues to drive in this manner. That's all for the state.
Okay. I was gonna ask the question and it has evaded me. So we'll just go to Ms. Wills. Ms. Wills, please proceed.
Thank you. My client is 33 years old. He is a native of Georgia. He is currently unemployed. However, as it was stated by the state, he did go to trade school and has the CDL. He also has a high school diploma. He is a proud father of 4. I would request a signature on bond, as this is a 10th violation and obstruction case. And if Your Honor is not so inclined, I would ask for a bond not to exceed $1,000.
Defendant is going to receive a $3,000 split bond. It'll be $1,000 surety on the fleeing and $1,000 signature through the jail for the each of the remaining charges to get the total of the $3,000 split. He's not to drive unless he has a valid license. Additionally, he's to have no alcohol, drugs, or weapons as a condition. Is there anything further?
No, Your Honor, thank you.
All right, best of luck to you, sir. That concludes your case at this time. Who do we have next?
Position 2, Ms. Barnes. Barnes.
All right, Ms. Barnes, your case is 23 CR 003806A. You're charged with criminal trespass. Do you understand your rights today?
Yeah.
Was that, that's, yes. All right, this is her first arrest, so we'll go to Ms. Falk.
Yes, Your Honor. If we could kill 2 birds with 1 stone on this, Ms. Barnes's co-defendant is Star Mac, which is position 12.
Okay.
All right, so the facts of this case are that the defendants were sleeping in, well, were not found sleeping, but they were found squatting inside of a vacant apartment at 250 Fulton Street, apartment 5 in Atlanta, Georgia. There was also a broken window at that location, and when they spoke with the apartment manager, Miss Chandra Ashley, she stated that neither of the individuals were supposed to be there. The apartment is Rose Burney Park Apartments. And on Miss Barnes, we're asking for a $1,500 signature bond through pretrial. Stay away from Rose Burney Park Apartments at 250 Fulton Street, and no alcohol, drugs, or weapons. The same, we are making the same recommendation on Mr. Mack as well.
Okay, understood.
It's Miss Mack.
Oh,
My
Miss Mack.
apologies, Miss Mack.
All right, Miss Wills, do you have any objection to the signature bond and stay away? Are there other conditions or other information you'd like to put on the record very briefly? Because I'm inclined to grant the signature bond.
No objection, Your Honor. My client is 17 and still a high school student. No objection to a signature bond. Thank you.
All right. All right. Defendant will receive a $1,500 signature bond through the jail. She stay away from that location in its entirety. Have no alcohol, drugs, or weapons. Best of luck to you, Ms. Ashley. Do not go back there, okay? Can we take position 12 now?
Yes, ma'am.
Thank you. All right, Ms. Mack, let me give you your case number. Your case number is 23 CR 003808A. You're charged with criminal trespass. Do you understand your rights?
Yes, ma'am.
All right, Ms. Howard, will you still put the history onto the record, please?
Yeah, hold on. This is her second arrest. She got open case in Clayton County. I just
Okay.
chatted you the charge, and it's terroristic threats and what I just chatted.
Okay,
Yeah.
all right. All right. Ms. Falk, does the state affirm their request for the $1,500 signature bond?
Yes, but we ask that it go through pretrial, especially
Understood.
considering there's a previous arrest here.
Okay,
And that case is open, so she wouldn't recommend it.
okay. Ms. McLeod?
Yes, Your Honor, my client is 17 years old, and she tells me she was just there at that location helping her friend to move. She was unaware that her friend did not actually live there. She is in school right now, Your Honor. She is at Atlanta Area Tech as a student. That is what she does, and she does live at home with her grandfather. Nothing further, Your Honor.
All right, we'll give her the same bond. Ms. Mack will receive a $1,500 signature bond through the jail. She's to absolutely stay away from those apartments on Fulton Street and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor.
All right, best of luck to you, Ms. Mack. Do not go back there. All right, who do we have next?
Position 14, Ms. Sayes.
Okay. Ms. Sayes, good afternoon. Your case is 23 CR 003803E. You're charged with battery and family violence with the offense date of May the 12th. Do you understand your rights?
Yes.
All right. Mr. Howard, can I have her history?
Second arrest, 2016 ag assault dismissed.
Okay, thank you. Ms. Falk, is this your case?
Yes, Your Honor. This happened May 12th, 2023 at 2738 Connolly Drive Southwest. Tony Robinson stated that he was in the kitchen cooking, had his headphones on when his defendant, his living girlfriend, spoke with him, but he could not hear her due to the headphones. At that point, the defendant snatched the headphones out of his ear. Mr. Robinson took the earphones back and put them in his ear. The defendant then attacked him by scratching his face and neck. He tried to leave, but the defendant began pushing him into things. Mr. Robinson to the police stated that the defendant left, returned shortly after, picked up a stick and struck him in the ribs. Officers did note scratches to Mr. Robinson's face and neck. Mr. Robinson is here in the Zoom and has talked to our victim advocate, told her that they live together at the incident location, share no children. And he did confirm that the defendant snatched the earbuds out of his ear and that she also grabbed his shirt, which resulted in her scratching his neck. He does want contact with Miss Sayes, the defendant, and he wants her to return to the residence. However, the state does have some concerns particularly in light of the seemingly unprovoked attack, as well as the prior arrest for aggravated assault. The state is requesting a $3,000 surety bond. Stay away from 2738 Connolly Drive Southwest. No further contact with Tony Robinson, and no alcohol, drugs, or weapons. As I said, Mr. Robinson is here on the Zoom, and we would like to sound for him. Thank you.
All right, I'm sorry, 2738
Connolly Drive. Yes, Your Honor.
Okay, and that's Atlanta?
Yes, Your Honor.
Okay. Mr. Robinson, I understand you'd like to make a statement. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, you can put your hand down. I am not sentencing the defendant today. So if you disagree with the facts as alleged by the state, that's not critically important. What's critically important to me is whether you wish to have contact with her and whether you have any concerns or fear for your safety. In light of those questions and those points, please, what statement would you like to make to the court at this time?
The whole story was kind of a lie. I did not tell him that. I said she well, the whole situation about the earbuds is right, but as far as her scratching my face and hitting me with a stick, I did not say she hit me with a stick in my ribs.
Okay,
And
so Mr. Robinson, again, I know that you may disagree with the facts as alleged by the state. That's not really what we're doing today. We're giving her a bond, and we want to make sure that the bond conditions address all of the concerns you might have about your safety. Do you have any concerns for your safety, and do you wish to have contact with her?
no concerns about my safety. And yes, we've been still contacting each other after that incident. It haven't been anything since then.
Okay, and then would you like to tell me anything else at this time?
No, ma'am.
All right. Thank you, Mr. Robinson. I appreciate you coming to court and making that statement. Ms. Kim, please proceed.
Yes, Your Honor. Ms. Sayes is 26 years old, Your Honor, and they are fiance relationship. They live together and they are trying to, they're planning to marry soon. My client is a single mother of 3 children. They are not a child with Mr. Tony Robinson, but my client has to work really, really hard to provide financially for those 3 minor children, 4 to 5. And she does not get any child support because it is so pending. Right now, she's the sole provider for kids. Your Honor, she is currently enrolled at cosmetology school, and she has certified CNA, and she has a medical assistance diploma, and she's trying to get better with doing hair and Uber and DoorDash, all kinds of jobs to raise money. However, she's still qualified for public defender services. So I would like to request for a signature on bond, Your Honor. 2016, almost 7 years ago, whatever the charge was dismissed. And this has been very remote. It happened about a month ago. We would like to request for no further violent contact with Mr. Tony Robinson and signature on bond. Thank you.
All right. At this time, defendant will receive a $4,000 signature bond through pretrial per judge. She is to take the 1-day anger awareness course. She's to have no further violent contact with the alleged victim and have no alcohol, drugs, or weapons. Is there anything further? All right, best of luck to you both. That concludes the hearing at this time. All right, who do we have next?
Position 5, Ms. Chandler.
All right, Ms. Chandler, your case is 23 CR 003812F. You're charged with simple battery, family violence, and simple battery against a police officer with the offense date of June the 13th. Do you understand your rights? Is that a yes?
That's a yes, ma'am.
All right, thank you. This is first arrest, so we'll go to, is it you, Ms. Folk?
Yes, Your Honor. This incident happened June 13th at 11:45 p.m. at 345 Haywick Trace, and that's Cawyck. in Johns Creek. The officer spoke to Marlo McDowell and determined that there was a physical altercation at that location. The defendant and Mr. McDowell are parents of a 4-year-old daughter and live together at the address. The defendant grabbed Mr. McDowell's necklace chain and pulled it, as well as his hair, during an argument to keep him from leaving. When the officers went to arrest her, she spit on the officer. The bond is currently set at a $3,000 surety bond on the simple battery against law enforcement only. We are asking for a $3,000 surety bond as to all the charges, reduce the simple battery law enforcement officer to a $1,000 surety bond, and then give a $2,000 surety bond on the simple battery. Stay away from 345 Kwick Trace in Johns Creek. No further contact with Marlo McDowell. No alcohol, drugs, and weapons. We would like to sound for Mr. McDowell at this time.
All right, is Mr. McDowell present and wishes to make a statement at this time? All right, hearing and seeing none. Ms. Kim?
Yes, Your Honor. Miss Chandler is a single mom of 4 years old. I mean, they are actually celebrating her birthday this Sunday. She's going to be 4 years old. Your Honor, she is 24 years old. She moved about 9 months ago because of her fiance, Mr. McDowell. She has been a stay-home mother ever since she moved to Georgia. She goes to real estate school to be licensed as a realtor. And yet, at this point, she is not making any income. So she is qualified for public defender's services. So we would like to continuously represent, and we ask for signature on bond in light of the fact that this is her first offense ever. And Your Honor, I believe that there was a misunderstanding about the fact. Since I could not contact Mr. Marlo McDowell myself, I cannot request for no further violent contact, even though that's what I want to do, since she has no other place to go at this point. We would like to request for a signature on bond and hopefully no further violent contact. Thanks.
All right, defendant's gonna receive a $2,000 surety bond, $1,000 on each count. She's to have no contact with Mr. McDowell, and she must stay away from that incident location. She can return one time with a member of law enforcement to get any items. Additionally, she's to have no drugs, alcohol, or weapons. Is there anything further?
None
A third party
Your Honor.
transfer of the child, please.
Oh,
Your
yes.
Honor.
Yes, she can arrange transport of her child by coordinating with the third party.
Thank you,
All
Your
right.
Honor.
All right, best of luck to you. Who do we have next?
Position 8, Mr. Douglas.
All right, Mr. Douglas, your case is 23 CR 003805Y. In this case, you're charged with theft by taking with the offense date of June the 13th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
Fourth arrest, 2022 failure to appear, 2022 theft by taking. That's it.
Okay, thank you. Mr. Robinson, please proceed.
Yes, ma'am. Hold on, please. Can you guys hear me?
We can.
All right, thank you. All right. So this incident happened on June 13th of this year at the location of 1470 Spring Street, Northwest Atlanta. The victim was a male named Christopher Angel Ortega. He's a shoe seller. He stated that one of the customers had stated that they needed him to buy a pair of shoes. So they meet up with he meets up with the customer along with 2 other associates, including the defendant. And then when that happens, they walk him down to a particular location, and then the shoe seller or the victim, Mr. Christopher, hands them a pair of shoes. All 3 of them decide to run off without paying for the shoes, Your Honor. And so then he calls the police, he calls the cops. He reports them. He had a friend follow them on social media and was able to identify them and also inform them that they stayed at the Ascent Midtown Apartments. And once Ortega accompanied the cops to their apartment and then found all 3 of the suspects in the apartment, Your Honor. He's been arrested for theft by taking, robbery, and criminal trespass in 2022. And the judge had already set the surety bond at $1,500 and the bond remained set. sorry. I request that the bond remain as set, along with no further contact with Christopher Angel Ortega, no alcohol, drugs, weapons, and anti-theft course.
Okay, thank you.
Your Honor,
Ms.
if I
Wood-
may, I'm sorry. to
Yes.
interrupt. We need to sound for our victim in every case, and so I just want to make sure we sound for our victim before we move forward.
All right, we'll sound at, this is stuff I take, and we'll do that at the end. Go ahead, Ms. Wills.
Thank you. My client is 19 years old. He has resided in the state of Georgia for the past 10 years. He reports that he likely has lost his job due to his arrest. He previously worked at Tomco, where he did packaging for them. He does have a high school diploma and did attend college for some time. He does not have any children and is unmarried. In speaking with my client, he states he is currently unable to afford the $1,500 bond as set. So I would request a signature on bond. He has no objection to staying away from the premises. And actually the address that's noted in the warrant is an Airbnb. And he states that his items, he still has items and clothing there. So we would request a one-time law enforcement escort for him to pick up any items he might have there.
All right. Is Mr. Ortega on this Zoom conference and wishes to make statements? All right, Mr. Robinson, what was the alleged value of the shoes? You're muted.
It was about $270.
Okay. All right, at this time, defendant will receive a $275 surety bond. He is to stay away from that incident location, have no contact with the alleged victim. He can return one time to the incident location with a member of law enforcement to get his items. Additionally, he's to have no drugs, alcohol, or weapons. Is there anything further?
Nothing from defense. Thank you, Your Honor.
Judge, how much was that?
$275 surety bond.
$275.
Yes, that's what it is, Mr. Howard. Thank you. All right, who do we have next?
Position 4, Carter.
All right, good afternoon.
Man.
Computer is moving very slow. All right, Mr. Carter, your case is 23 CR 0038007J. You're charged with simple battery family violence with the offense date of January 8th. Do you understand your rights today?
Yes, ma'am. Yes, ma'am.
You do, okay. Mr. Howard, can I have the history, please?
42 total. Got 2010 ag assault conviction, 2010 burglary, possession of tools conviction, 2012 ag stalking, harassing phone calls conviction, 2012 probation, 2016 probation, 2017 and 18 failure to appear, 2019 probation, 2020 forgery conviction, and last arrest was 2020 battery DV. That's open.
Okay.
20 CR 006104J.
Okay, understood. Ms. Falk, please proceed.
Yes, Your Honor. And at the conclusion of this matter, I just want to let you know I do have an announcement on Broughton, the potential
Add-on. Okay.
Yes. So this happened January 8th, 2022 at around 10:45. Officers responded to a domestic dispute over at we have the address of 4046 Esther Drive, Southwest in Atlanta, Georgia. They spoke with Miss Sherette McCullum, that is MCCOLLUM, who stated that she was watching a game and hanging out with her boyfriend, the defendant. She did not want to talk about anything anymore, so she attempted to go to bed. The defendant then became irritated, joined her in the bedroom, was yelling at her, harassing her. She said she told the defendant to shut the F up, and he proceeded to punch her in the lower side of her back. And when the officers arrived, they noted in the report as well in the warrant that Ms. McCullum was obviously in pain. Based on that, there was a warrant for simple battery taken out. I want to notate that this defendant has a previous open case with Ms. McCullum. That is at 20 CR 006104J case. That was a family violence battery. He had a bench warrant that was issued on August 22nd, 2022. and he was released on that case on a $4,000 surety bond. That, in addition to the aggravated stalking conviction from DeKalb and the aggravated assault conviction for DeKalb, paints a picture of a defendant who has a violent history and a history involving Ms. McCollum in particular. For that reason, the state is asking for a $5,000 cash bond. We are further asking for no further contact with Ms. Sherette McCollum. Stay away from the address at 4046 Esther Drive, Atlanta, Georgia. No alcohol, drugs, or weapons. We would like to sound for the victim, Ms. Sherette McCollum.
All right, is Ms. McCollum present and wishes to make a statement?
She is trying to log on to the Zoom, Your Honor. She's been calling me for some time. She was just calling me on the phone. She tells me she's having difficulty logging on, or she isn't being let in.
Okay. Well, why don't you proceed, Ms. McLeod? I'm sure if she comes on at some point, we can still hear from her. Ms. McLeod, please proceed.
My client is 50 years old, Your Honor. He and Ms. McCollum have been in a relationship for some time, she tells me. This alleged incident happened in 2020, I believe, based on what the warrant says. I have spoken to Ms. McCollum, and she tells me that she did not call the police, and she did not tell them that she wanted to press charges, that she and my client live together and have been living together for some time. And neither of them knew anything about this warrant, and it came as a surprise to her. She tells me that she wants to continue living with my client, that she has absolutely no issues with living with him, and she denies the allegations on the warrant. Your Honor, I don't know, she seems to be having some difficulty getting into the Zoom, because I did speak with her earlier, and while we were on, she did try to call me on the phone, because I'm assuming she's still having difficulty, Your Honor. But I'm going to try to see if I can get her back and help walk her through getting in to tell you what her wishes are with respect to bond for my client. A cash bond for my client is essentially no bond. And given how long ago this incident is alleged to have happened in 2020, and they've been living together since, and nothing has happened. So it's not a situation where he's likely to intimidate her or that they need a cooling down period, because she expressed to me that she was very surprised that he was arrested. Nothing further, Your Honor.
And just to clarify, this incident happened in 2022. I think Ms. McLeod may be confusing it with the first incident against Ms. McCollum in 2020.
Okay, but if it happened in 2022, it's a year ago, and they're continuing to live together.
All right, understood. Defendant will receive a $7,500 surety bond. He's to have no contact with Ms. McCollum and stay away from that incident location. He can return one time with a member of law enforcement to get any items. Additionally, he's to have no drugs, alcohol, or weapons as a condition. And should Ms. McCollum log on at some point, we will hear from her. All right. Best of luck to you, sir. What do we have next?
I'm sorry.
Oh,
No. What about the one she said I had,
Ms. Falk, what was your announcement?
man, they gave me a bench warrant for 2020 cases. I'm sorry,
Yes.
I speak, ma'am. They said I missed a court day. They gave me an $8,000 bond on the back for.
Okay, I don't want you to tell me too much. I want you to speak to Ms. McLeod, who can probably help you with this. I don't want you to say something that ends up being used against you, okay?
No, okay, I called her. They got me with another show.
Okay, Ms. Falk, your announcement?
Yes, Your Honor. On Broughton, the charge was linked, unfortunately, to the DA's number, but we got it unlinked. I'm working up the case now so that we can present it. We will need a PD, I'm assuming, to interview Mr. Broughton, or because he has a $55,000 surety bond, we can do that or reset it to tomorrow. It's either or for me. We can be ready.
I can speak with him. I do not have any further clients on today's calendar. If I could just receive the warrant information, I'd be happy to call him at the jail.
I'll email you the warrant now.
Thank you.
Okay. And if someone could give Ms. Wills the phone number to call the jail, I appreciate that.
He's calling now. Judge, what was the bond for Mr. Carter, please?
$7,500.
Thank you. You gotta talk to Ms. McLeod about that.
Resolution number 10 at ACDC.
Hold
Good
on.
afternoon, Your Honor.
Go ahead and have a seat.
Okay. All right.
Near her right.
I'm sorry, Your Honor. I think it sounds like my client wanted to say something, but I was actually speaking to Ms. McCollum. She had called me back.
Yes,
What was it?
I'm asking about the money that had a bench
Can
warrant.
he give you a call so we can keep going?
Yes,
Can
Your
Ms.
Honor.
McLeod call the jail? Let him speak to her that way. Okay, Ms. McLeod's gonna call the jail. We're
I
gonna
will.
go to position 10, 23 CR 003800C. In this case, defendant, Ms. Hanks, you're charged with battery, family violence, and cruelty to children in the 3rd degree. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney at this proceeding. This proceeding is being broadcast over the internet as a live stream. It's also being recorded. That means any member of the public can watch this. Do you understand that, Ms. Hanks? Okay, you're muted, but I saw that you said yes. Mr. Howard, can you please give me that history?
Your Honor, I believe this is a conflict case. I just want to make sure.
Oh, Ms. McLeod, this is Ms. McLeod's case?
Yes, I believe she's on the phone with the previous client.
Okay, so Ms. McLeod, are you still speaking with the other gentleman? And the
No, Your Honor, I wasn't able, the jail did not answer.
Okay, we'll take this case then, if you could do that and give the jail a call once we finish.
I think they're calling me now, Your
Oh,
Honor.
they're calling you now. Okay, Ms. Hanks, you'll be on hold. Who do we have at courtroom 2?
This is position 11, Howard.
Okay. All right, Mr. Howard, your case is 23 CR 003801G. In this case, you're charged with 2 counts of loitering and prowling. Do you understand your rights?
Yes.
Okay, Mr. Howard, can I have the history, please?
6 total. Last arrest was 2003 obstruction, possession of tools, and failure to appear. Before that was a 97 burglary.
Okay, understood. Thank you, Mr. Howard. Ms. Falk, please proceed.
Yes, Your Honor. In this case, the officers were called out to the area of, my apologies, just a moment. The officers were called out in regards to the defendant being inside of a vehicle. They spoke to first. I'm so sorry, Your Honor. I'm just taking a moment to, for some reason, I'm having problems locating my notes on this case. Just a moment.
That's all right. It's one of those days today.
It is indeed. All right, so they spoke to Mr. Eric Austin, who stated he received a call that the defendant was entering his vehicle, which was parked on private property. Mr. Austin arrived at the scene and saw all of his car doors open and mud and shoe prints on his seats. He then observed the defendant walking down the street. He had actually been called by another individual that this defendant was in his car, and he saw the defendant who matched the description that was provided by him. Mr. Austin then made contact with that defendant, asked why he was in his car, and the defendant stated, "F you, I'll do it again," and approached him in an aggressive manner, causing Mr. Austin to then strike the defendant and the defendant to strike Mr. Austin. The officers also spoke with Erica Millen L., who stated she saw the defendant in her yard and inside of her vehicle. She asked him to leave and presented the officers a recording of him on her cell phone attempting to open her driver's side door before he was stopped by police. So that is the basis of the 2 loitering and prowling, and my apologies, I misspoke, before he was stopped by Miss Millen L. So the state's recommendation on this case is a $2,000 surety bond. We're asking for $1,000 on each loitering and prowling. We are also asking that he stay away from the private property of Eric Austin and Erica Millen L. And that's going to be the 1200 block of Bolton Road Northwest. Furthermore, we are asking for no further contact with Erica Austin and Erica Millen L, no alcohol, drugs, or weapons. Quite frankly, this was basically close to a criminal attempt to commit entering auto, but we have no information that items were taken or removed from the car, which is the reason why we did not upgrade the case. That's all for the state.
All right, Ms. Kim, please proceed.
Yes, Your Honor. My client is 58 years old, and Because of the accident, he does have a disability, Your Honor, and he was probably a little bit confused. However, nothing was stolen. And my client was actually struck by one of the complaining witness, who was a first primary aggressor. Anyway, my client is currently, he's residing with his father, who is 84 years old. He has his own place and phone number. He has one child who is 38 years old, and he graduated from high school. Your Honor, we have to kind of understand that he may have to continue with his disability treatment. And yet, we would like to request for a signature on bond, since all the other charges were very remote. The last one was from 2003, 20 years ago. We would like to request for a signature on bond. Thank you.
Defendant will receive a $1,500 surety bond, $750 on each count. He is to stay away from the address on Bolton Road and have no contact with either of the alleged victims. Additionally, he's to have no drugs, alcohol, or weapons. Is there anything further?
Nothing,
right,
Your Honor.
Best of luck to you, Mr. Howard. Who do we have next?
Judge, that's it. We just still waiting on the, Mr.
What
Brown.
about position 9? Was there an announcement for position 9?
Your Honor,
Forward. I'm sorry,
Your
Ms.
Honor,
Kim, is there an announcement?
yes, position 13, Render Lamont. I filed a waiver of appearance, so I can go forward with him about him.
Okay, and what about 9? The number 9 bond out?
He's in felony. They're gonna grab him real quick, Judge.
Oh, okay.
My understanding was that that was a felony transfer case.
So Miss PD Wills, one was a felony transfer case. He has actually several cases. We were able to transfer one because of the prior family violence battery, but we could not transfer this because it was a simple battery family violence.
All right, then I'll call the jail and speak with them then.
Okay, and in the meantime, can we go back to position 10? The young lady at ACDC. Ms. McLeod, are you available?
I am, Your Honor.
All right. And we had just said that Ms. Hanks understood her rights, and Mr. Howard was going to give me position 10's history, please.
Fourth arrest, last arrest was in March, battery DV. 2019 probation and 2018 disorderly conduct conviction.
Okay, thank you. Ms. Falk.
Yes, Your Honor. This happened June 13th, 2023 at 9:41 p.m. So yes, 2 days ago at 5007 Upper Elm Street in Atlanta. Mr. Kenyatta Beverly stated the defendant, who he shares a child with, was upset during an argument and began hitting him and threw a glass at him. The altercation happened in front of their child, KB, who is an infant. Mr. Beverly had a bruise to the left side of his face. He also showed officers footage of a video where the defendant was the main aggressor and was hitting and throwing items at Mr. Beverly. So based on both the video and the injury, the officers placed Ms. Hanks under arrest. Mr. Beverly has been allowing defendant to stay weekends at the residence. I will just say there was a previous charge against both of these individuals in March for family violence against each other, where Mr. Beverly was told to have no further contact with the defendant. In this case, the defendant's case was dismissed at that time. However, the defendant does have an open case under 22 CR 005534C for simple battery against Mr. Kenyatta Beverly, but it did not have a bond amount or conditions. It looks like she was given a citation at the time. For those reasons, we are asking for a $5,000 surety bond, stay away from 5007 Upper Elm Street in Atlanta, no further contact with Kenyatta Beverly, no alcohol, drugs, or weapons. At this time, we would like to sound for Mr. Kenyatta Beverly.
All right. Is Mr. Beverly present and wishes to make a statement? All right, hearing and seeing none, Ms. McLeod.
Yes, Your Honor, my client is 22 years old. She tells me that she was not the aggressor in this instance. What she tells me is that Mr. Beverly took her telephone and he smashed it. So she was a little upset about that because she was waiting to call someone to pick her up, but he smashed her phone and she was going to call 911, but she was unable to because the smashed phone. So she was arguing with him about the fact that he had smashed her phone, and he took his phone and started to do a recording after he had been the aggressor and had come at her and had smashed her phone. I understand that there was a previous arrest between these two parties, Your Honor. They share a child, a 7-year-old. They were not married at the time of the child's birth, of course. And based on my conversations with her, he has not legitimated the child. She would prefer no further violent contact with Mr. Beverly, Mr. Kenyatta, I believe his first name is. They actually do not live together, Your Honor, but because they share the child, she had been spending weekends with him from time to time, but she has her own separate address, which she's given to me in Riverdale. My client does not work. She stays at home and takes care of her child. So she's therefore not in a position to post any kind of bond, Your Honor. So I would ask the court to consider giving her a signature bond because she was not the primary aggressor here. So she can get out of jail and go back home to take care of her 7-year-old. The court can see that she has bandages on her hands, and this was as a result of when he broke her phone, her hands got cut because there was glass and all kinds of things all around. He knocked the phone out of her hand and she was trying to get the phone, and her hand is cut. You can see that her hands are bandaged, Your Honor. So I would put to the court that he was in fact the primary aggressor, and he took this video just to try to convince other people that she did something wrong. Nothing further, Your Honor.
All right, defendant will receive a $2,000 surety bond, $1,500 for count 1, $500 for count 2. She's to have no contact with the alleged victim and stay away from that address on Upper Elm. I understand that she does not live there. However, should she need to return to get any items, she can return one time with a member of law enforcement. She can use a third party to arrange and coordinate transport of that child. Additionally, she's to have no drugs, alcohol, or weapons. Is there anything further?
Nothing further. I did try to reach out to Mr. Beverly, but I was unable to get a hold of him.
All right. Best of luck to you, ma'am. That concludes your case at this time. All right. Are we able to go to another position? Has Ms. Wills had the opportunity to speak to?
Yes, this is Mr. Broughton, spoke to Ms. Wills.
Okay, Ms. Wills, you're ready?
Yes,
Okay.
Judge.
All right. This is the add-on case.
Your
Can
Honor,
someone give me the,
sorry to interrupt. If we could address the waiver instead, I'm still filing down that case and getting an accusation number.
Okay, we don't have a number yet, so we can't take Mr. Broughton. We will take the waive case, unfortunately, unless we can do position 9. Can we do, Ms. Wills, have you had the chance to speak to that gentleman?
No, I had sent a message to the jail. When he's done over a felony, can they give me a call?
Yes, he's en route.
Okay, thank you.
Okay.
And then.
All right, so we'll do the waive case while we wait, unfortunately, for courtroom 2. We'll take the waive case of the position 13, Lamonte Render 23 CR 003802J, in which defendant is charged with criminal trespass and damage to property with the offense date of May the 23rd. Mr. Howard, can I have that history, please?
28 total. 2019 failure to appear, probation. Got an open case, 2 counts of shoplifting, trespass, obstruction. It's 14 SC 126745 on probation for robbery. 12 SC 107083. Also appear to be on probation for burglary in the 2nd degree. But that should time out soon. And he got a parole hold because he on parole
Okay.
for robbery.
Okay, thank you. Ms. Falk?
Yes, Your Honor. This happened while the defendant was inside the jail on May 23rd of 2023. Apparently he interfered somehow with the light switch. The officer at ACDC smelled the smell of smoke coming from inside the cell. And when they opened the cell, the defendant was assigned there by himself. They could see the light switch was burned and the cell light was not working due to it being burned. The defendant was then charged. We are asking for a $500 surety bond. and we can't ask for a no further contact or stay away. So we're just going to ask for no further.
Yeah.
We're going to ask for no alcohol, drugs, or weapons, and that's all for the state.
Okay. Ms. Kim, please proceed.
Yes, Mr. Render is 29 years old. Of course, he cannot go anywhere. Your Honor, he denies the allegation. Actually, he says that it was not him that actually broke the light. He totally says it was already broken, and then the smoke came from the under his cell, but I was not there as an investigator, but that's what he claims. And right now he's got a job and he wants to start his new life. He was in jail until like end of the May. And so he's very excited about this life. He does not want to go back to jail. He has a high school diploma, and he's not going to be qualified for public defender services. We would like to request for a signature on bond. Thank you.
In Your Honor, just to let you know, he's currently on hold with no bond on a parole violation and has a $5,000 surety bond on a theft by receiving under 23 CP 216423.
Okay, as for this case, defendant will receive a $2,000 SOB through the jail. I don't believe we can do any other conditions at this time, but I'm sure that perhaps this case can be resolved as part of a global resolution with his others.
We just asked for no alcohol, drugs, or weapons.
And yeah, so I would hope that those aren't available at the jail, but no alcohol, drugs, or weapons. All right.
Oh, objection. Thank you.
All right.
We're already on Broughton. I have the case number if Your Honor needs the case number.
All right. If you would just put the case number onto the record for me, Ms. Falk, that would be great.
Your Honor, the case number is 23 CR 003824A, and he is charged with 1 count of simple battery.
All right. And sir, do you understand your rights? All right. Ms. Howard, do you have the history?
Yeah, I got it.
Okay.
This is 4th arrest. Last was January 2022, possession of drug-related objects, possession of MDMA with intent. 2021 ag assault, and 2018 misdemeanor possession of marijuana, possession of a controlled substance.
Okay.
Yeah, that is all.
All right. Thank you. Ms. Falk?
Yes, Your Honor. This happened back on October 24th, 2022 at 1124 Wiley Street in Atlanta, Georgia. Apparently the defendant and his sister were staying at that apartment complex. She was waiting, Miss Terica Broughton was waiting on the first floor, and she stated that her brother, the defendant, kicked down her bedroom door, demanded money from her, and punched her in the face. She further stated that he's been demanding money from her because he is not able to retrieve his stimulus check, and she had been calling 911 for the past few days regarding the same incident, and the police had done nothing about it. The officers did observe that the door to Miss Broughton's bedroom was knocked down, and she stated she was holding her child at the time of the incident, but he did not touch her child, A.B. The state's going to recommend in this case a $2,500 surety bond. We're also going to ask for no further contact with Ms. Terica Broughton, as well as no alcohol, drugs, or weapons, and the defendant stay away from 1124 Wiley Street in Atlanta, Georgia. I will say that we have not had an opportunity to speak with the victim about this case, so I right now, out of an abundance of caution, we are asking for no further contact and a stay away order. Thank you, Your Honor. That's all.
And I'm assuming Ms. Broughton is not on the Zoom conference. I still sound in the chance that she is. Ms. Broughton, if you're present and would like to make a statement, this is your opportunity. Hearing and seeing none, Ms. Wells, please proceed.
Thank you, Your Honor. My client is 24 years old. He is a native of Georgia. The address, his mailing address that he does use is different from the incident location, and I did not have the opportunity to receive the warrant. I received it from Mr. Carter. So I was not able to confirm with him this 1124 Wiley Street address. However, he states he is employed as a contractor. He works odd jobs and will not qualify to be represented by the Public Defender's Office. He does not have any objection to not having any further contact with his sister or staying away, well, from the address he provided me, but I would like the opportunity to just ask whether or not my client resides at the 1124 Wiley Street address.
All right, you can go ahead and ask your client that, Ms. Wills.
Okay. Is that where you live, Mr. Broughton?
No, ma'am. I'm on sale at 3101 Brownfield Road.
Okay, all right. So we would have no objection to staying away from the incident location and no contact. I would request a signature on bond.
All right.
But and also, I did want to note on the record, I'm sorry, Your Honor, that my client did receive a $50,000 bond today in felony court.
Okay. Defendant will receive a $1,500 surety bond. He's to have no contact with the alleged victim, stay away from that incident location, and have no alcohol, drugs, or weapons. That's a condition. Is there anything further?
No, Your Honor.
And Your Honor,
All right. That's
$1,500 surety bond, is that correct?
correct. All right. Best of luck to you, sir. That concludes your case at this time. And then was that the entire calendar? We did not do
We
position
still have
9.
board.
Position 9 remains, and we await that case. Okay, and we do need to address it today. I see that he's been booked in on that charge for 2 days. So we would have a concern if we reset. In the meantime, as we await, can we review the calendar? Is Ms. Bridgewater here?
Absolutely, Your Honor.
Thank you.
Okay, once again, the reset date for the SAP calendar is going to be June the 29th. Position number 1 is reset further notice with a $2,500 SOB through the jail. Position 2 is reset further notice with a $1,500 SOB through the jail. Position 3 is going to the SAP calendar with the $3,000 total split bond. Position 4 is going to the SAP calendar with a $7,500 good bond. Position 5, SAP calendar with a total $2,000 good bond. Position 6, SAP calendar with a $2,000 good bond. Position 7 is going to the SAP calendar with a total $3,000 good bond. Position 8, SAP calendar with a $275 good bond. We're still holding on position 9. Position 10 is going to the SAP calendar with a total $2,000 good bond. 11, SAP calendar with a total $1,500 good bond. Position 12 is being reset further notice with a $1,500 SOB through the jail. 13 is being reset further notice with a $2,000 SOB through the jail. Position 14 reset further notice with a $4,000 SOB through pretrial per judge. Position 15 is being reset further notice with a $2,000 SOB through the jail. And then on the add-on, it is going to the SAP calendar with a $1,500 good bond. Are there any questions, comments, otherwise? Okay.
All right. And we are still holding on position 9.
That is correct.
Okay. I guess we'll be on a very brief recess. Thank you all for your patience.
Okay.
All right, good afternoon, sir. I am Judge Melanie Williams. Today is June the 15th. We're going to hear your case. Hold on. Is Ms. Wills, Ms. Falk, everyone back?
Yes, Your Honor.
I seem to have temporary, okay, here's the calendar. All right, your case, sir, is 23 CR 003813D. You're charged with simple battery, family violence, and willful obstruction with the offense date of June the 14th. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney. I'm conducting this proceeding over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch. Do you understand your rights and how I'm conducting the hearing today?
Yeah, ma'am.
All right. Is Mr. Howard here to give us the history? If not, Ms. Falk, do you have the history?
Judge, I
you-
got it. I'm getting this felony bond amount now. Shelly, you
Okay.
wanna go while I get it?
Yeah, sure.
All right.
That's fine. So, Your Honor, there is I am going to allude to the history, however, but in this particular case, this happened at the address of 110 Grayfield Lane. It occurred on June 14th, which was yesterday at 9:15 a.m. The officers spoke with Miss Savannah Ford, who is married to the defendant. She stated that during an intense argument regarding communications that she found on his phone, he snatched her phone from her hand, which caused her to drop her key fob and then caused her to fear for her safety. She did call the police, and when the defendant saw the police, he fled from the sight of the officer and hid, and then was later arrested. The inherent issue here, Your Honor, is there is a lengthy history involving this defendant and Miss Ford. In particular, the defendant has, and I don't know if they involve Miss Ford, but convictions from 2015 and 2016 for family violence battery, which was the reason his new case, one of his charges for family violence battery involving Miss Ford, was upgraded this morning to the felony division. Additionally, he has two open cases, one in Superior Court and one in state court, different from the one I've just described. One was a battery, third or subsequent offense, and 3 counts of cruelty to children in the 3rd degree. That case happened in 2021. That is 23, excuse me. That case is under 22 DA 05508. The defendant received an $11,000 surety bond on that case, as well as a stay away order from from 2110 Southwood Lane and no further contact with Savannah Ford. Then in March 17th of 2023, Your Honor gave him a $1,500 surety bond for theft by taking involving property belonging to Miss Savannah Ford. You also ordered a no further contact with Savannah Ford and a stay away from Grayfield Lane, where this incident yesterday happened. So in total, we are not only seeing a violent history in the past for which the defendant has convictions, but he now has 1, 2, 3, 4 open cases with Savannah Ford, all with the exception of these most recent 2 with bonds. According to pretrial, he got no bond in felony court. We are asking for a $4,000 cash bond, $3,000 on count 1, $1,000 on count 2, that he have no further contact with Savannah Ford, and that he stay away from 110 Grayfield Lane in Sandy Springs, Georgia. No alcohol, drugs, or weapons. Your Honor, I cannot emphasize enough how dangerous this is and how far this is progressing, that multiple orders have now been violated for a stay away from Ms. Savannah Ford. We would like to sound from Ms. Ford at this time.
All right, is Ms. Ford present? All right, hearing and seeing none, Ms. Wills.
Thank you, Judge. My client is 27 years old. And so I did hear that he has some prior convictions from 2015 to 16 when he would have been 19 or 20 years old. He was previously employed by Popeyes as a cook. However, due to the fact that he has no bond currently, he will likely lose that job and will qualify for our services. He does have a high school diploma. He is married to Miss Ford. However, in speaking with him, he does understand that they cannot have any contact and he will not be returning back to the residence. I would request a one-time law enforcement escort for him to pick up any belongings that he has at the home. It's my understanding, he told me that he does not have any children. And as it was stated, he has no bond in his felony case. So I would ask for a signature on bond. In this case, the facts as alleged are that my client snatched a phone out of Miss Ford's hand and caused her to drop her car key. So I would ask for a signature bond. If Your Honor is not so inclined, I would ask that his bond not be greater than $1,000.
All right, defendant is gonna receive a $2,500 cash bond. It was 2 counts. Let me double check. Let me make
Yes, Your
sure that
Honor,
I get.
willful obstruction
Okay.
and simple battery.
Okay, so there'll be 2,000 on count 1, 500 on count 2. He's to have no contact with Ms. Ford whatsoever, and he's to stay away from that location on Grayfield Lane. He can return one time with a member of law enforcement to get any items. Additionally, he's to have no drugs, alcohol, or weapons. Is there anything further?
That's it, Your Honor.
Your Honor.
All right. All right, best of luck to you, sir. I believe that concludes the entire calendar. We've already reconciled it. So we will be in recess until tomorrow's SCA calendar. All right, take care, everyone.
Your
Thank you.
Honor, I'm sorry.
Afternoon.
You said both of those was cash?
Yes.
All right, thank you.
All right, take care, everyone. Have a good afternoon.
You too.
All right, bye-bye.
All right.